I want to tell you about the phone call my father received on a Thursday evening from the attorney he had hired to sue me, and about what that attorney said, and why he said it, and what it cost my father to hear it from someone he was paying $800 an hour to tell him the truth. But I need to start where this story actually begins, which is not in a Nashville law office and not on a Thursday evening. It begins in a kitchen in Knoxville, Tennessee, when I was 22 years old and told my father I had been accepted to the Army's Judge Advocate General's Corps. My father, Richard Wells, was a commercial real estate developer who had built a successful business over 30 years through a combination of intelligence, stubbornness, and the particular confidence of someone who had never been seriously wrong about anything he considered important. He was not a cruel man. He loved me in the genuine and perfect way of fathers who have strong opinions about what their children should become and find it difficult to separate that love from those opinions. His opinion about the JAG Corps was delivered with characteristic brevity. He said, "Karen, you went to law school to practice law, not to wear a uniform." I said, "I want to do both." He said, "You can't do both. You can practice law or you can play soldier. Pick one," I said. He said, "Then I hope you figure out what you actually want before you've wasted too many years." That conversation established a dynamic that persisted for the 16 years that followed. My father had filed his assessment of my career choice and he did not revisit it. Every holiday, every phone call, every family gathering came with some version of the same underlying message, that I was intelligent and capable and I was spending both in an institution that would not reward either in the way they deserved. He was not entirely without basis. The Army's legal system is not the same as civilian practice. The cases are different, the courts are different, the professional culture is different, and the pathways to the kind of visible success that my father understood, the big firm partnership, the high-profile client, the legal reputation that translates into social currency, do not exist in the same form inside a military institution. What he had no way of evaluating, because he had stopped paying attention to the specifics of my career approximately 3 years into it, was what 16 years of JAG practice had actually produced. I commissioned as a captain and tried my first case at Fort Bragg, North Carolina, within 8 months of completing my JAG basic course. The case involved a complex fraud scheme within a contracting unit, the kind of financial crime that required understanding both military regulations and civilian commercial law simultaneously. I won. My supervising officer noted in my evaluation that I had demonstrated an unusual combination of technical legal precision and courtroom presence for an officer at my experience level. That evaluation set a pattern that continued for the next 15. I deployed to Germany, to South Korea, to Kuwait, and twice to Afghanistan. I tried cases in military courts that handled everything from minor disciplinary matters to serious felonies under the Uniform Code of Military Justice. I handled complex administrative law issues involving military contracting, environmental compliance at installations, and the legal dimensions of joint operations with allied forces. My last posting before retirement was as a senior legal advisor to a NATO command in Brussels, where I spent 2 years navigating the legal frameworks of 17 different national militaries simultaneously. I retired at 38 with the rank of lieutenant colonel. My father described my retirement as me finally coming to my senses. He asked when I was planning to join a real firm. I told him I was opening my own practice, focusing on military law, veterans benefits, and government contracting disputes. He said, "After 16 years, you should be starting at partner somewhere." I said, "I'm starting at the top of my own firm." He said, "That's not the same thing. The estate dispute began when my grandmother died." My grandmother, Eleanor Wells, was my father's mother, a woman who had lived alone in Knoxville for 30 years after my grandfather's death, managing her own finances with the sharp attention of someone who had grown up during the Depression and never fully trusted that prosperity would last. She had approximately $1.4 million in assets when she died at 87, accumulated carefully over decades of frugal living and shrewd investment in real estate that she had purchased incrementally starting in the 1970s. I had been close to Eleanor in a way that I was not close to most of my family. She was a woman who valued directness and competence, who had no patience for performance without substance, who had followed my military career with genuine interest, and she had come to my JAG basic course graduation. She had sent me letters in Afghanistan, actual handwritten letters, 3 pages each, full of Knoxville news and recipes and the particular warmth of someone who wants you to know that home is still home while you are far from it. When she revised her will in the final 2 years of her life, she left me a larger share of her estate than she left my father or my Uncle Gerald. The revision was not dramatic in percentage terms. She moved approximately 12% of the estate from equal division to a slightly preferential distribution in my favor. But the dollar amount on an estate of that size was significant. And my father's response to it was the response of a man who had been wrong about my worth for 16 years and had just received documentary evidence of someone else's assessment. He decided the will had been the product of undo. He hired Gerald Moore. Gerald Moore was a civil litigator with 30 years of practice in Nashville, a reputation in the Tennessee bar that was genuinely substantial, and a client list that included several of the most significant real estate developers in the state. He was, by any reasonable measure, exactly the kind of attorney my father would hire when he wanted to make a point about resources and seriousness. The first meeting between my father and Gerald Moore took place on a Monday morning. I know what was discussed because my uncle Gerald, who had been present and who told me about it afterward with the combination of embarrassment and resignation of someone who has spent 60 years watching his older brother make confident decisions, described it in detail. My father had explained the family situation, the estate, the revised will, his belief that a lien had been. He had described me in the context of explaining why he was confident the dispute would resolve in his favor, as someone who would be unprepared for civil litigation. He had said, "She's just a soldier, she won't know what she's doing in a civil courtroom." Gerald Moore had said he would review the matter fully before their next meeting. What happened in the hours between that Monday morning meeting and the Thursday evening phone call is something I have reconstructed from what Gerald Moore later told me directly, in a conversation I want to describe carefully because it matters to the full picture. Gerald Moore was, as my father had correctly assessed, very good at his job. Part of being very good at his job was that he did not take a client's characterization of an opposing party as complete information. He had a research process. He applied it. Within approximately 48 hours of the Monday meeting, Gerald Moore knew the following things about me. He knew that I had graduated in the top 10% of my law school class. He knew that I had commissioned into the JAG Corps and had practiced military law for 16 years across multiple postings. He knew that I had tried approximately 60 cases in military courts over the course of my career, with a record that any litigator of any kind would have found impressive. He knew that I had published 2 articles in military law journals that were sufficiently well regarded to be cited in subsequent scholarship. He knew that I had served as a senior legal advisor at the NATO command level, which meant I had navigated the kind of multi-jurisdictional legal complexity that most civilian practitioners never encountered. He knew that I had retired at lieutenant colonel and opened my own practice, and that the practice had been operating for just under a year with a client roster that suggested I had brought my professional reputation with me intact. He also knew something that was perhaps the most significant piece of information for his specific assessment of the situation. He knew that in the Tennessee State Bar community, where military law intersected with civilian practice in the areas of veterans' benefits and government contracting, I was not unknown. I had appeared in 2 federal proceedings in the District of Tennessee since opening my practice. I had been cited in a legal aid organization's annual report as a pro bono contributor of unusual sophistication. The federal judges in the district knew my name. Gerald Moore called my father on Thursday evening. He said, "Mr. Wells, I've completed my review of the matter and I need to speak with you directly about several things." My father said, "Of course." Gerald Moore said, "I'm withdrawing from this representation." My father said, "I beg your pardon. I'm going to explain my reasoning, and I want you to hear it fully before you respond." He said, "Your daughter is not just a soldier. She is a lieutenant colonel in the Judge Advocate General's Corps who retired after 16 years of active practice in military law. She has tried approximately 60 cases. She has published legal scholarship. She has advised a NATO command. She has a federal court presence in this district that I am aware of and that the judge is in. If this matter proceeds to litigation, I would be walking into a courtroom with a credibility disadvantage that I am not willing to accept against an opposing counsel whose professional reputation in certain circles exceeds my own." My father said, "She's my daughter." Gerald Moore said, "That's correct, and I want to be honest with you about something else." He said, "After reviewing the estate documents and the circumstances of the will revision, I'm not confident this case has the merit I would require to take it to trial. The revision was executed by an independent attorney. There's no documentation suggesting undue influence. Your mother's physician has indicated she was of sound mind at the time of the revision. The percentage change in distribution, while meaningful in dollar terms, is not dramatic in percentage terms and falls within the range of testamentary discretion that courts typically respect." He said, "I could tell you that we have a strong case. That would not be true. I could tell you that I can successfully argue undue influence without evidence that would satisfy the standard. That would also not be true." He said, "I think the most useful thing I can do for you is tell you the truth, which is that this case against this opposing counsel with this evidentiary record is not a case I would recommend pursuing." My father was quiet for a moment. He said, "She's just a soldier." Gerald Moore said, "With respect, Mr. Wells, that's the assessment you should examine before you proceed with any other attorney. Because the attorney who faces her in court will discover what I discovered, and they will be in a less comfortable position to give you honest advice once they've already taken your money. He withdrew the following morning. I learned about the call from my Uncle Gerald, who had heard about it from my father, who had apparently described it in terms that suggested he considered Gerald Moore's withdrawal a failure of nerve rather than a professional assessment. My uncle said, "Your father is planning to find another attorney." I said, "I know." He said, "Diana, sorry Karen, I've been watching your father underestimate people for 60 years. He does it to everyone who doesn't fit his framework. I want you to know that I have never underestimated you. Not since you were 12 years old and argued with your grandfather about property law at Thanksgiving and were right." I did not remember that Thanksgiving argument, but My father found another attorney, a younger litigator named Paul Simmons, who had been practicing for 8 years and who had either not done the research Gerald Moore had done or had done it, and decided the case was worth taking anyway. The litigation lasted 4 months. I want to describe those 4 months carefully, because they were the most professionally interesting months I had experienced since retirement, and because I think the description matters to the full picture of what 16 years of military law practice actually produces. Military courts do not operate the way civilian courts operate. The rules of evidence are different, the procedures are different, the culture of the courtroom is different. What transfers between the two systems is not procedure but something more fundamental: the capacity to build a case methodically, to cross-examine effectively, to anticipate opposing arguments and prepare responses in advance, to remain calm and precise under pressure in a room where the stakes are real and the audience is paying attention. I had done all of those things in courts that were in their own way considerably more demanding than the civil courtroom I found myself in for those 4 months. Paul Simmons was competent. He was not outmatched by incompetence. He was outmatched by experience, by someone who had spent 16 years in rooms where the pressure was real, where the preparation had to be complete, where there was no margin for the kind of imprecision that a less demanding environment might allow. The case settled in my favor in month 4, after a deposition in which the key witness my father had expected to support his undue influence theory provided testimony that directly contradicted his narrative. I will not describe the deposition in detail because some of the specifics are subject to the settlement terms. What I will say is that the preparation for it had taken 3 weeks, and that the 3 weeks of preparation produced a deposition that Paul Simmons later told a mutual colleague he had not been prepared for. He said it apparently without rancor. As a professional observation about what 16 years of JAG practice looks like in a deposition room, my father did not attend the deposition. He was not in the courtroom on any of the 4 months' worth of hearings. He received reports from Paul Simmons, who I imagine gave him increasingly honest assessments as the proceedings developed. After the settlement, my father called me. He sounded tired, not defeated. My father was not a man who expressed defeat easily or completely, but tired in the way of someone who has been carrying something heavy for longer than they expected to and is beginning to feel the weight. He said, "I want to talk about what happened." I said, "Okay." He said, "Gerald Moore called me after he withdrew. He told me some things." I said, "I know he did." He said, "He told me I had underestimated you." He used that word specifically. I said, "Did he?" He said the attorney who would face you in court would discover what he had discovered and that they would be in a less comfortable position to give me honest advice once they had already taken my money. I said that was accurate. He was quiet. He said, "Paul Simmons told me the same thing at the end. He said he had not fully understood who he was going up against." I said, "They both did their research." He said, "I didn't." I said, "No." He said, "I told Gerald Moore you were just a soldier." I said, "I know." He said, "I've been telling myself that for 16 years, that you were just a soldier. That the uniform was a costume and the career was a game and eventually you would come back and do something real." I said, "I know what you've been telling yourself." He said, "Gerald Moore spent 2 days looking at your record and withdrew from a case he'd already agreed to take. That doesn't happen because someone is just a soldier." I said, "No, it doesn't." He was quiet again. He said, "What do you actually do, the practice?" "What is it?" I said, "Military law, veterans benefits appeals, government contracting disputes, federal litigation for clients who have been wronged by the defense." He said, "People who have been wronged by the defense procurement system." I said, "There are more of them than you'd think." He said, "I've been in defense contracting for 30 years. I said, "I know." He said, "And you spend your career fighting for the people on the other side of that." I said, "Sometimes, not always. The system is complicated." He said, "I imagine it is." We talked for another hour. He asked questions he had never asked before about the cases, about the courts, about what federal litigation in the district actually looked like, about what a NATO legal advisory posting required. I answered what I could answer and described the broad shape of things when the specifics were privileged. He listened in a way he had never listened when I talked about my career before. Not with the polite patience of someone waiting for the conversation to move to a topic he found more tractable, but with the focused attention of someone who has just discovered that the room they have been walking through for 20 years contains something they had never looked at directly. At the end of the call he said, "I owe you more than an apology for the lawsuit." I said, "Yes." He said, "I'm starting there anyway." I said, "Okay." He said, "Karen, Gerald Moore told me something else." I said, "What?" He said. He told me that in his 30 years of practice he had withdrawn from representation 3 times, that I should understand how unusual it was, and that the person who had caused him to withdraw was someone he would not want to face under any circumstances in any courtroom. He paused, he said that as a professional assessment, not a compliment. I said, "I know the difference." He said, "So do I now. I am 39 years old. I practice military law in a firm I built myself from the reputation I accumulated in 16 years that my father spent calling a game. I have a father who is starting, at 67, to look at the right picture of what those 16 years produced." Gerald Moore spent 48 hours looking at my record and made a decision that cost him a client and $800 an hour. My father spent 16 years not looking and made a decision that cost him a lawsuit, an estate share, and eventually the settled certainty that he had always known best. The research Gerald Moore did in 48 hours was available to my father for 16 years. He just never thought to look. There is one more thing I want to say, something that happened after the settlement that I have not shared with anyone in my family. Gerald Moore called me directly about 3 weeks after the case closed. Not about the case, it was over and settled and there was nothing left to discuss professionally. He called because he wanted to say something he apparently felt he had not fully said in the conversation with my father. He said, "Miss Wells, I want to tell you something that I told your father in a limited form and that I think you deserve to hear completely." I said, "Okay." He said, "In 30 years of practice, I have withdrawn from representation 3 times. Once because I discovered my client had been less than truthful with me about material facts. Once because of a conflict of interest that emerged after the engagement began. And once because of you." He said, "I want you to understand what that means. I withdrew because I reviewed your record and concluded that proceeding against you would be professionally unwise." That is a different category of withdrawal from the other two. It is not about ethics or conflict. It is about competence, mine relative to yours in this specific context. He said, "I have a reputation I have spent 30 years building. I was not willing to risk it against someone who would take it apart in a courtroom in a district where the judges know her name." I said, "I appreciate you telling me." He said, "I'm telling you because I think your father needed to hear what I told him, and I think you deserve to know the full version of it. The version is this: I have faced excellent opposing counsel many times. I have faced counsel who outmatched me in specific areas of law. What I have not often faced is someone who combined the trial experience you have with the specific kind of composure that military legal practice produces. It is a particular combination. I recognized it in your record before I would have encountered it in a courtroom, and I made the decision I made." He paused. He said, "Your father told me you were just a soldier. I want you to know that I found that characterization after 48 hours of research to be among the most inaccurate descriptions of a legal professional I have encountered in 3 decades of practice." I thanked him. He said, "One more thing." I said, "Yes." Said, "The research I did in 48 hours was publicly available. Bar records, court filings, published articles, professional references. Nothing I found required special access or unusual effort. It was simply information that existed and that I looked for." He said, "I don't know whether your father ever looked, but if he did look and still described you the way he described you to me, then the problem was not information. It was a decision about what to see." I said, "I think that's right." He said, "I'm sorry it took a lawsuit for him to make a different decision." I said, "So am I. I have thought about that call many times since, not about what Gerald Moore said about my record, though that mattered. What I have thought about is the last thing he said. The problem was not information. It was a decision about what to see. My father had access to everything Gerald Moore found. Not the classified portions of my military record, those were not available to anyone outside the appropriate channels, but the public record, the bar registration, the court appearances, the published scholarship, the professional reputation I had built in a city he passed through regularly for 30 years. He had never looked, not because the information wasn't there. Because looking would have required him to update an assessment he had made 22 years earlier in a kitchen in Knoxville and had never revisited. He said, "You went to law school to practice law, not to wear a uniform." He said it once and filed it and closed the file. Gerald Moore opened the file in 48 hours and understood immediately that the file contained something different from what my father had described. That is the full shape of the story. Not the lawsuit, not the settlement, not the 4 months of litigation. The 48 hours, the decision to look, the information that was always available to anyone willing to see it. I am 39 years old. I practice law in a firm I own. I have a father who's beginning imperfectly and late to look at what was always there. Gerald Moore spent 48 hours doing what my father had 22 years to do. Sometimes 48 hours is enough. Sometimes The difference is not time, it is the willingness to open the file.